Shoes. Recorded live.
Well, good evening, everybody. This is Matthew, and we are kicking off another Wednesday night call. This is our regularly scheduled The Free Americans conference call, Wednesday at 8 p.m. Eastern, 7 p.m. Central. And before we get started, just want to give a quick disclaimer, what this call is about and what this call is not about. First and foremost, we are not attorneys. We are free men and women gathering together to discuss ideas, a group of men and women who are standing upon the land. We're here because we love America, which is one nation under God. We're here to talk about how we can make it a stronger nation by talking about the truth. So, with that said, if you take any of the information that's given on this call, one thing I want to caution you on is that you use this information in a way that you own it. In other words, do not blame somebody else if a process that you try does not work. If you put your name on it, you sign it, you put your energy behind it, then it's yours and you own it, so take responsibility for it. And if you do have any questions tonight, you can go ahead and hit star 8, and we'll go ahead and see you show up here on my computer screen, and we'll unmute you when the appropriate time is available. And if you do have a question, be sure to ask the question in such a way that you would ask what we would do if we were in that situation, because we do not give any legal advice. We're not tax accountants or attorneys, and so we don't give any of that advice out on this call. So just want to make that clear. I'm going to go ahead and mute everybody out now, and we'll bring Christian on here, and we'll go ahead and get started. So if you're ready, Christian, it's all yours.
Okay, thanks, Matt. Well, my name's Christian Walters, and I'm the host of Money, Banking, and Trust by Moving Titles and Commerce on every Saturday night at 7 to 9 p.m. Eastern Time. That's the title of the show, Money, Banking, and Trust by Moving Titles and Commerce. And I'm the host of that show, and I always discuss a private educational program, whether in court or out of court, whether it's civil or criminal, and covering the root causes of all problems under public policy, or AKA bankruptcy or commerce. And it's really, the intent of the show is for giving the tools that are available that we have to achieve standing and gaining rights, titles, and interests through creating titles, claiming your titles, and moving your titles, also known as the straw man or any other colorable title. And I usually address problems for academic informational purposes only. And I address hearings, investigations, arraignments, trials, arrests, kidnappings under color of law, whether they be credit card debt, property foreclosure, IRS tax liens, traffic tickets, arrest, and payments of all bills through private credit using promissory notes or money orders. And I also know about ZYA and BIC methods, and we're really using the tools, and the tools are the UCC, the GSA forms, and the IRS forms as enforcement. So that is on at every Saturday from 7 to 9 p.m. Eastern Time, and the call-in number for that show is 712-432-8773, and the PIN number is 179441#. And it can also be accessed on the Internet off that from a website called therealpublicradio.net. Last couple of weeks we had the server down, and we haven't been able to uplink to that, so it might not be available next week, but I suspect after the week after that it should be. So we've been talking about trust, and then I'm going to continue on trust, especially the expression of the trust or the intent of the expressing of the trust. And really, anytime that you're signing anything, you are forming a relationship by your signature. And it needs to be a trust relationship expressed, or it could be another type of relationship. And another type of relationship might lack the necessary elements of a trust, and you may think you have a trust and you don't. And the 4 elements of a trust are the trust intent, the specific trust res, and 3, the designation of the parties. That would be the settlor, the trustee, or the beneficiary, although it's not always necessary to express the trustee at that particular time. And then 4, a valid trust purpose. So the intent, number 1, would be to create the trust, and it's manifested by the settlor's words or their conduct. And I kind of stress or conduct. So they can get you in trust that you don't even know exists. And I've read some things that even the grantor doesn't even have to know that a trust relationship was formed. So no parties in the trust might even have a realization of a relationship that was formed, but that does not determine whether or not a trust was formed. So it's not the knowledge of it, whether all the parties had knowledge of it, it was the relationship formed, because the courts will say, hey, there was a trust formed here, and even though all the parties, grantor, trustee, and beneficiary, had no idea they were forming a trust. And that seems kind of wild, but that's where they go. So then it has to be the specific trust property, and it has to be also property that's transferred in the now, and it has to be presently owned property. So you have the settlor, he has to have capacity, and you have the trustee, and a trust generally will not fail for lack of a trustee, but then under a different section, and I'm going from Gilbert's law summaries really, if you wanted to check under section 137, it says on page 35, it says, caution, without trustee, an intended inter vivos trust, or maybe another trust, may fail for lack of delivery. So it should be noted, however, that the absence of a trustee may result in the failure of the attempted creation of an inter vivos trust because of the requirement of present and effective transfer. So in other words, if there is no trustee, there is no one to whom the delivery can be made. Without delivery, there is no transfer and thus no trust. So hence the trust fails for lack of transfer, not for want of a trustee. Because anytime there is a want for a trustee, the trust can be run through a court, and the court will appoint a trustee if there's no trustee. So as long as you have a valid trust, there's no worry in not whether you have a trustee, because it could be appointed. But you don't want to mess it up because of failure for lack of transfer, because a delivery cannot be made, and without a delivery there is no transfer and thus no trust. So watch out for that one. So now we have the first of the three parties, the trustee, and now we go to the second party, which would be the beneficiary. They have to be identifiable. And the last one would be the valid trust purpose, and that would be one that is not illegal or tortuous or against public policy. And I would say that our valid trust purpose should be House Joint Resolution 192. So the payment or discharge of all debts, dollar for dollar. And if that has been recodified, you can always find it in split up under, 48 Stat 112, as well as Public Law 73-10. So the expressions of the trust, expressing the intent on the documentation that we put into court, which was just basically 3 lines, that I think just covered basically a notification to the court, say, in this mortgage foreclosure, that a trust existed, but there were really no specific details other than alluding to, and there was really not enough information in there to specifically spell out the grantor or the settler's intent. And that would leave room for the court to construe it, but although I really don't want to bring in the specifics of the real man, or the substantive rights of the real man in trust, and bring it into open court on the public side through the clerk of the court, and thereby waiving it. And if you look under Federal Rules of Evidence, Rule 501, or how it comports to your local state, and in particular Florida here, where I'm from, it's 90.501 through 90.510, and specifically 0.506. 0.506 is privilege with respect to trade secrets. So I'm saying that this trust of the substantive man and the private rights has to be maintained on the private side and cannot be crossed over into the public through the court, because you're going to waive the trade secret. It's privileged information. And it has to be protected under your local court rules, and under Florida it's 1.280 C7, I believe, where it's confidential, it's commercial, and it's secretive, and it's private. And I want to maintain its privacy, and how I'm going to do that is to bring it in chambers by letter rogatory on the private side and keep it on the private side, but yet at the same time mirroring into the public side the mirror image of it by notification and notification only, thereby not waiving it. Because anytime I talk about it in open court, I will waive the privilege. And then under 90.507 talks about waiver of privilege by voluntary disclosure. So I would check out Federal Rules of Evidence, Rule 501, in your state and find out how it comports to your local state rules and find out where it's talking about privilege with respect to trade secrets and waiver of privilege by voluntary disclosure. Because you don't want to work so hard at putting all this together in 30 seconds, give it all away in court. So anytime we form a relationship with the signature, the relationship needs to be checked or expressed in a certain way by a restrictive signature, and then you have to have the specific trust elements to make up the trust, or else it'll be construed or will actually be another type of relationship. Another type of relationship would be debtor-creditor relationship or agency or some other type of, which we talked about in one of those other shows that we discussed, the other relationships. But the elements of a trust all have to be there or you do not have a trust. And those are four elements. That's number one is the trust intent. Number two, the specific trust res or property, the principal. And three, the designation of the parties. That would be the settlor, the trustee, or the beneficiary. And four, a valid trust purpose. Now, the intent or expression of the trust in general, it's essential to the creation of the trust that the settlor objectively manifest a final, definite, and specific intention that the trust should immediately arise with respect to some particular property. And that's immediately arise, the now. So this does not mean that the intended trust cannot be revocable. And then the form of expression. Now, there must be some external manifestation of intention by words or by conduct. And it's not enough that the settlor's intent was formed in her own mind, but that they gave no external manifestation of it, but nor are vague expressions, or precatory language, they call it, vague expressions of donative intent sufficient. The settlor must manifest a specific intent to create as some particular property, a relationship known in the law as a trust. So it must be something that they can recognize. And they're going to recognize these four elements. And if you have these four elements, then you have a valid trust. So back to the court case that I was talking about. Let me find something here. I'll pull up that case and give the basic expression. Or really, I would say it would be more of an NOI, which is a notice of interest or notice into the court of the existence of a trust, but really doesn't specifically spell out all the details necessary to prove the trust. Now, I don't want to put all that information in the court. I want to hold the details for in chamber, but I only want to put a notice of the trust on the public side through the clerk of the court. And I put that on the headings of all my documents I put in there. Almost there. Okay. What I put together is just a basic notice. It's noticing the court, and it basically says in about 4 lines, says, without waiving any right, remedy, or defense, whereas I, the real man, am competent with intent and purpose as grantor/settler. Now, you could take out grantor, you could leave settler in there, but right after the settler, I have a footnote. Take you into the footnote. So it says that the purpose as grantor/settler of the expressed, revocable, modifiable trust filed, now coming as the beneficiary in the above named action in good faith, states as follows, and then the rest of your case. So then now the footnote. Footnote says, number 1, it says unlawful or illegal purpose in construing trust. Unlawful purpose should not be imputed to settler. And then there's a couple cases here. And I'm continuing on. It says the purpose for which trust may be created, quote, the intent and purpose of the settler of the truth is the law of the trust. That's a quote right out of a case, Edmondson versus First National Bank of Birmingham. And there's a couple other case sites there. So let's go over the four elements of a trust. One is intent. Two is specific trust res. Three, designation of the parties. And four, valid trust purpose. Now let's take that statement and measure whether or not we have those elements in there. Do we have a trust intent? Okay, it says here, I am competent with intent. So there is intent in there, although the intent is not particularly detailed. Number two element, the specific trust res. Okay, it says that with intent and purpose as the grantor/settler of the express revocable trust filed. So that's talking about a trust that's been filed. So there must be some kind of specific trust that's been filed. So you still have, enough notice there that there was a trust filed, a specific trust, but yet there's not enough there to identify it yet particularly. So three, the third element, designation of the parties. So we got to have settler, trustee, and beneficiary, but not all the time the trustee. Keep that in mind. So without waiving any right, remedy, or defenses, whereas I, the real man, am competent. So they're saying it is competent with intent and purpose as grantor/settler. So right there, the real man is connected to be the grantor/settler, and it's identifying specifically who the settler is of the trust. So we have the settler down. So now trustee. So of the express revocable modifiable trust filed, now coming as beneficiary, now we've got the third party, beneficiary, in the above named action in good faith states as follows. So the trustee is really not named, but that could be named later. That doesn't mean the trust is not valid. So we do have the two pertinent parties necessary to form the trust, the beneficiary and the grantor. That's named in this paragraph. And the last element, a valid trust purpose. So whereas I, the real man, am competent with intent and purpose as grantor/settler. So it says the purpose. So we have intent and purpose already demonstrated, and we have the four elements of a trust. And if we take it down to the footnote, where the quote out of the case, it says, the intent and purpose of the settler of the truth is the law of the trust. So the law of the case is the intent and purpose, and that is the law of the trust. And the only thing we really need to identify is the specific details now. So you have given the court notice that a trust exists, and when the judge asks you, well, what's this trust stuff here? Well, I'd be glad to tell you about it, Judge, but this is private, secretive, and it needs to be protected, and I will set a hearing for in chambers. We can discuss it in there. Now you didn't waive the information, because if you went into the details right in open court, you would have waived it. So now I put together the details, the specific property, and everything else in detail to demonstrate the specific intent in the indenture, and put that by letter rogatory in chambers in court. And that's where I'd be discussing that information. Otherwise, I'm going to waive it. So that would be the form of expression, words or conduct, and the particular wording. So no particular words are required. The term trust need not even be used, nor is it essential that the settler or any of the parties involved know or understand that the intended relationship is a trust. And if the court finds that the parties intended to form a certain relationship with respect to property involved, and the law defines that the relationship is a trust, then the party's intention to enter into a relationship requisite trust was intended then. So the use of the term trust, parties may refer to their relationship as a trust, but if the requested information is lacking, then it's an essential element is missing, and not to be provided by the court, then there is no trust. And then the use of other terms. Even if a party proclaim their intention to create a bailment or an agency or guardianship or other relationship like debtor-creditor, the court may find their real intent was to create a trust. So the court would construe it to be a trust then, even though it was in the wrong relationship, and then vice versa also. So the communications, provided there is some external expression, And it says essentially some admissible evidence. That's what we're looking for. We're looking for a record, some kind of evidence on the eternal expression, which is going to be your words. The settler's failure to communicate the trust intention to the beneficiaries or others does not prevent the trust from arising. So there's an example here for an envelope was found in a safety deposit box, and it was marked, quote, held for my nephew, Thomas Smith, and constitutes a sufficient manifestation of the intent to declare a trust of the contents of the envelope. So now we jump down to precatory expressions, which is weak language. It's not direct, it's not commanding. And its intent is really uncertain, and it opens the door for the courts to construe and form a resulting trust, and they're going to form it or construe it on their own bias bent, that you were required to make payments, say in a court case, under Federal Reserve notes instead of making with private credit. So the intent is uncertain, and usually the settler directs or commands. So he commands or directs the trustee to manage the trust property for another, but on occasion she may simply express a hope or a wish or a suggestion that the property be so used. And this type of expression is called precatory language. And whether precatory expressions create trust or only unenforceable moral obligations or less is a matter of interpretation, a matter for the court to decide what the transferor intended. So there leaves the door open. So the early view was that weak language was okay, but in the modern view today, such courts are reluctant to infer the trust intent from precatory words, and such expressions presumptively create no enforceable obligations, and that's right out of the restatements of the Law and Trust, the third. So for the court to find a trust, the transferor must have intended to impose a legally enforceable obligation on the transferee, and not merely a request, giving the transferee an option to use designated property for the benefit of another. So a trustee cannot have uncontrolled freedom with respect to the use of the trust property, but must be required to manage it for another, unless otherwise set in the indenture for the trustee's use. Put that caveat in there. So the construction, the words of the testator or transferor or settler will normally be given their literal meaning, and precatory expressions will not ordinarily be interpreted as a general way of expressing a command. So that's the way they look at it. And then other evidence of trust intent. When precatory words are interpreted in context and coupled with other factors now, however, courts may find sufficient trust intent. So the following evidence or circumstances may be relevant. And number one is definiteness. The court will examine the instructions to the alleged trustee to see if they are definite, specific, and detailed. The more definite, specific, and detailed the instructions, the more likely it will be held that a trust was intended. And we're going to leave this detail and specific and detailed definite stuff, we're going to leave that for the leterogatory, and it's private and secret, being held for in-chamber discussion. And two, fiduciaries. The court will consider whether the instructions are addressed to someone or otherwise stands as a fiduciary capacity. The language addressed to a fiduciary is more likely to be treated as expressing a trust intent. Language addressed merely to a legatee or a divisee is less likely to be held to express trust intent. And then three, unnatural disposition. The court will look to see if the imposition of a failure to impose a trust would result in an unnatural disposition or result of property, and it would end up with nothing under the will, say, and previously supported person would be left in need, or a stranger would inexplicably end up with extraordinary gift. So they would compare that to with the intent of the grantor or settler, and it would be deemed as an unnatural disposition of the property and probably be modified by the courts. So a time and place, number four. The court will determine whether an absolute gift was made first and the precatory words were later inserted. So often lessening the likelihood of the trust then. So a disposition initially made in unconditional terms is not to be reduced by later language in less clear terms, according to some courts, or whether the words of a gift or precatory language are included in a single sentence or paragraph, which may lessen the reluctance of some courts to infer a trust intent. And then 5, there are other circumstances. The court will also review whether other circumstances indicate that a trust relationship was intended, and any pre-existing relationship between the parties or other expressions of purpose or state of mind may have the alleged settlor would be seen to indicate a trust relationship was likely to have been intended. So time when the trust intent must be expressed. So the rule is that the intention to create a trust must exist and be manifested by words or conduct at the time when the settlor owns or is transferring the intended res of the property. So the prior or contemporaneous expression of trust intention may be made, 1, by transferor, or 2, by the transferor and transferee together, or 3, by the transferee with reliance upon thereon of the transferor. So gifts now under what must be expressed. The settlor cannot convey property as an outright gift and later execute a trust instrument declaring the gift was actually in trust, and after acquired property next, where a voluntary trust intent is held and expressed by a person purporting to be the settlor. Now that's like our documents here. There was this expression of the trust here. We're purporting to be the settlor, but prior to her acquisition of the intended trust property, courts will probably find this to be sufficient manifestation of intent to create a trust if there is some further manifestation of trust intent by that person, either by conduct or by words, after acquiring the property and consistent with their prior expression. So, for example, such subsequent conduct might occur by segregation of the property and making income payments to an intended beneficiary of the trust, thus establishing by declaration, or it might take the form of subsequent delivery of the property to another as a designated trustee. And I might want to mention the find it here quick. Methods of trust creation. There's 4 methods of trust creation. One is by declaration, and that is specific res is held in trust for another, and you declare that. And 2, transfer, which is created, a trust is created by the transfer of property. And 3, by appointment, where a trust is created by the power of appointment. And 4, by contract. And a contract promise to create a trust in the future. So there's 4 methods of trust creation: declaration, transfer, appointment, and contract. So back where we were. So the trust must be intended to take effect immediately. So its effective date would be now. And that's what I had in those 4 lines. And that was to establish by the intent of the grantor. So the trust must be intended to take effect immediately. Another factor to consider in determining whether a trust has been effectively created is the time when the trust was intended to take effect. The settlor must intend the trust to take effect immediately, even if subject to revocation, and not at some future time. This assumes, as is usually the case with trust, that there would be a settlor, that the would-be settlor does not receive consideration that would make an expressed or implied promise to create trust in the future enforceable. In the case of an intended declaration of trust, remember that's one method of formation, declaration, if the settlor's manifestation indicates an intention only to become trustee in the future, there is no effective declaration of trust. And similarly, in the case of a trust to be created by transfer, second element of method of forming. So if the settler merely manifests an intention to establish it by transfer in the future, there is no trust, both for lack of present intention and for lack of essential present transfer. So note that under either of these circumstances, a trust does not arise later without further action at the contemplated future time. And on the requirement of a transfer, note also the close interrelationship between that requirement and the required trust intent. So there was an example on that. So a sister writes to the brother and says, as soon as the harvest is completed, I want you to have my farm, which you are to hold in trust for your children. Or another one was, when I return from Europe, I shall make myself trustee of the cash in my safe for your children and shall invest it for them until the youngest reaches 21. So no trust is created in either of these circumstances because the intended trust is to take effect only in a future time. So under a subsequent action, if, however, there is an appropriate subsequent act or a transfer, in the case of declaration, of segregating the res, that is consistent with the previously stated intention, and with intent that the trust presently take effect, a valid trust will then arise. Thus, in the first example above, if the sister delivers the deed to the farm to the brother after the harvest is completed, that would be a present transfer accompanied by the manifestation of the present trust intention that is implied from this conduct together with prior expression. And this would cause a valid trust to arise at that point. So, or in the second example above, if a sister on a return put the cash in an envelope marked for her brother's children, and there would be an effective declaration of trust at that moment, even if the sister would die before investing the funds. So the effect of postponing designation of essential elements now. If the owner of the property executes an instrument purporting to create a trust, but providing that the beneficiary, trustee, and trustees are to be designated later, the incomplete terms of the trust are evidence that the settler intended a trust only in the future and there would be no present trust. And now the trust of future interest. As long as the trust takes effect immediately, the trust itself may consist partially or entirely of the present existing future interest. And now trust of promise. So this could be under contract. So an unenforceable, that is gratuitous, promise to create a trust in the future does not create a trust. And there is neither a present transfer nor an intention to create a present trust. So that may be just a contract to form a trust in the future, which would be one method of forming, but it's not now. It's in the future, so it's not a trust until that time. So we have the effect of consideration now. If consideration is given for a promise that is otherwise enforceable at law, an example would be by damages, or in equity, an example would be specific performance, so then the intended beneficiary's rights can be enforced. And we might want to reverse this around a little bit and plug in some different terms. So the effect of consideration, or the exchange of a promise for a promise. So if consideration, that would be our property, is given for a promise, let's say the discharge of debt under House Joint Resolution 192, and that is otherwise enforceable at law, so example by damages, or in equity by specific performance, which would be the discharge of the debt, then the intended beneficiary's rights can be enforced. Think about that a little bit. So the better view probably is that the promise itself being viewed is creating no actual trust for lack of present transfer, and there is an enforceable right to have a transfer made and agreed trust established at a later date. Another interpretation of this situation would view it as creating a present trust of a choose in action, and that is with the enforceable promise as the res. And remember that enforceable promise would be House Joint Resolution 192 to do the discharge. And that promise is the trust property, the res, the principal. So let's go back to the case. Say we've got this mortgage foreclosure case, and what is the res in this intent here? Not specifically mentioned, although it is. So without waiving any right, remedy, or defense, whereas I, the real man, am competent with intent and purpose as grantor or settler of the express revocable modifiable trust filed is past tense, so that's in the now. It's been done, but it's also said that this trust has been filed. So anything you put your signature on is forming a relationship. Don't you sign these documents? By signing the documents, you are forming a relationship. By signing these motions, by signing these receipts. And under UCC 3-3115, it's really an incomplete instrument coming in through your mailbox or in your court indictment or charge or your foreclosure or whatever it is. And it's an incomplete instrument looking for your signature. And under 3-117, there are other contracts that are attached to that. And that's all they're looking for. They're looking for your signature. They're looking for the formation of a relationship. But since you didn't express the trust, you allowed them to construe it, and now they construe it with their own bias bent, and you got to pay in Federal Reserve notes instead of making private payments with credit, your own credit. And it even gets better than that as we go along. So the res of this particular subtrust, this court action, would be the document itself, which is really a negotiable instrument. Unless you express it as being a trust, then it would be non-negotiable. That's the trick. They're trying to get you under debtor-creditor, which is negotiable under Article 3, 8, and 9. And they're going to do that because you didn't express the trust by the rule of the signatures. Because you didn't sign by grantor, by trustee, by beneficiary, or by authorized representative by the grantor assignment of a Form 56 to the authorized representative to make him co-party to, say, the trustee. So now they construe the trust, and it wasn't your intent. Now you can go back and correct the whole mess because you got that power. Even if it was designated as being irrevocable, it was still not the grantor's intent. And under the little footnote, it's the intent and purpose of the settler of the truth is the law of the trust. So whatever the intent and purpose is of the settler, that's the rules of this trust. And it wasn't my intent. I made a mistake, and I'm going to come back in and reform this trust or revoke it or modify it. I'm going to come back in and modify it maybe as, well, I'm now able to make private payments with private credit instead of these stinking Federal Reserve notes that you're construing. And therefore, effectively, you have the ability to make the payment then. Or I could come in here and re-sign some beneficiary, the rights of the beneficiary, or make him beneficiary, and if he's trustee also, anytime the trustee is one and the same with the beneficiary, the trust terminates. And now the trustee has a personal liability because he no longer has any protection under the trust, and he must distribute the funds. So who is the funds supposed to be meant for?
They're meant for the beneficiary, aren't they?
Yeah, the beneficiary. There's a case, United States Bankruptcy Court, District of Nevada. It's Joshua and Stephanie Mitchell, Enrique case, March 31st, 2009. So this is a federal bankruptcy court in Nevada, and they are making reference on page 5 and page 8, and at the footnote footnote 31. Let me back up, and I'll read it a little bit. So it says, it's a foreclosure case, and it's talking about Mears. So, but more importantly, it says, even if Mears, as nominee of the beneficiary, or the motion was brought by the beneficiary, that mere allegation is not sufficient to confer standing. Under Nevada law, so this bankruptcy federal case is quoting Nevada law. The Nevada law, a negotiable promissory note is enforceable by 1, the holder of the note, or 2, the non-holder in possession of the note, who has rights of the holder. And thus, if Mears is not the holder of the note, then to enforce it, Mears must be a transferee in possession who is entitled to the rights of the holder or have authority under state law to act for the holder. And simply being a beneficiary or having an assignment of a deed of trust is not enough to be entitled to foreclose on a deed of trust. And for there to be a valid assignment for purposes of foreclosure, both the note and the deed of trust must be assigned. The mortgage loan crisis consists of a promissory note and a security agreement, typically a mortgage or a deed of trust. And there's where the 31st footnote comes in right there. So it says then when the note is split from the deed of trust, the note becomes a particular matter, it's unsecured, a practical matter, unsecured. So the person holding only the note lacks the power to foreclose because it lacks the security, and the person holding only the deed of trust suffers no default because only the holder of the note is entitled to payment on it. And now we jump down to the footnote 31. Nevada recognizes that parties may secure the performance of an obligation or the payment of a debt by means of a trust, deed of trust. And now they quote Nevada Revised Statute, section 107.020, where it says, the maker of the note is the trustor. So that tells me right away that on a promissory note, we're talking about a trust. And then it continues on, it says, and the payee is the beneficiary. So the payee is the one that the check or the promissory note is made out to, and that's usually the bank. So we know that the payee or the bank is the beneficiary then. And the maker of the note is the settlor, the trustor, the grantor. Now that's from Revised Code statutes. Now if that's in Nevada law, and this is federal bankruptcy, then it's probably codified in every 50 states somewhere. And it might be wise to go look and see if you can find out where that is. So the maker of the note is the trustor grantor according to U.S. federal bankruptcy and Nevada Revised Statutes 107.020, and that means it will be in other states also, and the payee is the beneficiary of the note, which is the bank. So now a deed of trust is really a deed is an act. So it's and that secures the performance or payment of the debt. And the debt, if you've got a debt, you're under debtor-creditor law. And by an act of trust, which is a deed of trust, because a deed is an act, so it's an act of trust. That's what a deed of trust is, an act of trust, filed on a UCC-1, the security agreement, which has been construed as debtor-creditor, or as the trust receipt, a specific or a special deposit under trust law. By being expressed, it is non-negotiable and private. So we need to check out the definitions in Black's Law of trust receipt, special deposit, and trust deposit. And you'll see that those make a circle. So if we take a piece of paper and draw a circle, and we split the circle down the middle with a dotted line, and almost to the bottom, then we make an upside-down T. On the bottom, we draw another dotted line, making an upside-down dotted T within that circle. And what we're doing is we're forming a ledger sheet. On the left side, that's the liability side. That's the debtor side. And on the right side of that upside-down T is the asset side, or the private side. So the right side is the trust account, and the left side is the debtor account. So now draw another circle down below that, and that's you as the grantor. And then you draw a line from that lower circle into the right half of that T under the asset side where the trust account is. And that's where you placed your promissory note held in trust. Now the bank knew it was a trust, although you didn't. So you never expressed it being a trust. All the bank knew was So on the left side is where the UCC got filed with your security agreement. So now notice, asset side balances the other side, except you never told them to do the adjustment or the adding and subtracting. And they're sitting there in a perpetual wait for you to give the instructions, because if the moment you were closing at escrow, if you would have told them from any time past that to take my funds that I held in trust, which is my promissory note, with a special deposit or a trust deposit, which is non-comminglable funds, and in order for a trust relationship to form under that reality of that relationship, you would have to ask for in-kind in, in-kind back out, or non-comminglable funds. And we talked about this, I think, on another show, where the example would be if I gave you $500 in 20s, if I just said, okay, give me $500 back in 2 weeks, what we had was just a debt relationship under debtor-creditor law. And you owed me back $500 in any denomination. You could give me five $100 bills. A trust relationship was not formed. But if I would have asked for the specific exact 20s in kind to be given back to me, what I gave to you, then that would have been a trust relationship. And you had the obligation to give me back the exact same thing that I deposited into you with. Same thing if I gave you my pen. I gave you my pen, I said, I want my pen back. I want that pen back. Now we have a trust relationship. And I didn't have to specify to anybody there was a trust. Didn't have to, no words were spelled out that it was trust or anything. It just was a relationship that was formed, and that relationship has all the elements of a trust, and it is a trust. But it's the important part is that the same deposit in has to be gotten back out in kind and not commingled. So when I ask for the note back after the closing, if it's a trust relationship, they have to give it back to me, because that's why the trust was set up. If they don't, they'd be in breach of fiduciary duty as trustees, and they would also be in breach of trust. But since the note has the beneficiary on it, who is the bank is the beneficiary. So they're actually functioning as two parties, beneficiary and trustee. But remember what I said about the trustee being the same as the beneficiary. The trust terminates, and now there's no trust protection. They must distribute the funds. But how they get around that is they have a title company be the trustee. So in your closing, the title company is holding your promissory note, waiting for the instruction for you to tell them what to do with the note. And from that time on, you abandoned it, which gives them the ability to keep on investing it, and that's what they've done. And they're still waiting, they're holding funds for you and using the funds and waiting for you, but you never come back and give them any instructions and tell them what to do with it. What you should have done was you said, I want my note back, or give me the proceeds from it, and then apply the proceeds to the beneficiary or debtor side of the ledger. Therefore, at the time of closing, during the count out, and the mortgage was paid. And it was all under trust law instead of debtor-creditor law. That can be redone at any time. You can still go back and get the house payments, as well as all the investments made against the trust note, promissory note, and you can do that at any time, even after the house was foreclosed upon. So you as a grantor never expressed the trust with the trustee orders to disperse or distribute the funds to the beneficiary. So they, as trustee, construes through the courts the asset as a debt under debtor-creditor law. And they invest the asset held in trust by securitizing the asset and thus commingling the funds in a breach of trust. So now they're in trouble. So they were still waiting for you as the trustee to give the orders to distribute the funds, but it's been abandoned. So the thing is to find out the trustee, who is a title company, what did the trustee do with your note as to the deposit being held in escrow? Because if they were the agent of the bank, then if they used the bank, who was the beneficiary, as one and the same party, then as agent, then the bank is essentially the beneficiary and the trustee, even though the title company is holding the promissory note. If they deposited it in the same bank that's the beneficiary, that would terminate the trust, because the bank would be both one and the same, beneficiary and trustee, even though they're using the title company, which after the trust terminates, they're supposed to distribute the funds to the beneficiary. And then who would the beneficiary be? That would be the bank. That would have paid the UCC security agreement filing and all that. It would have paid it off, and you would have had the house clear and free at that moment. So we could also use 90 and 91 and Form 28, but I think we're using these forms wrongly. Form 91, that's a release of property from escrow. And Form 90, that's a release of lien. So you get the house by instructing the trustee to release the payment or the promissory note to the beneficiary on Form 90. And you get the house by releasing escrow, the payment or the promissory note held in trust on Form 91, along with the Form 28. Because the 28, 90, and 91, the GSA forms, are the grantors or the trustees' instructions telling a party what to do.
That's on the public side, right, Christian?
Yeah. So I hope we can see applications of the trust here and applying it into situations, that we're going through right now.
Have you had success with these forms?
People have had success using these forms, but I don't think they've used them in this way, though. Actually, as an instruction to the parties through a trust.
Okay.
I think they've been using them under debtor-creditor law instead of trust law.
Okay.
I think that when we don't express the trust, right back under UCC, under negotiable instruments with these promissory notes, and here it was a non-negotiable instrument, not under Article 3 with these promissory notes, if you would have expressed the trust. And non-negotiable means it can't be commingled with anything else because it can't be negotiated. But they're construing it as being, well, you didn't say it was a trust, and since you're the grantor, but, remember what I said or read earlier there, that the grantor could form a trust relationship and not know about it. And we wonder how we get into these messes. And it's just as simple as somebody gives you their pen, and they say, I want that pen back, and you didn't know you had a trust relationship. And if you didn't give the pen back, you'd be in breach of fiduciary duty, and you'd be in breach of trust, and they could come at you under trust law and sue you for breach of trust. So the specific property was this promissory note that was held on the asset side in a trust account through a special deposit or a trust deposit. And then the UCC was filed. Some of them, they don't file the UCC ones, but anyway, because they securitize them. I think that's why they don't file them. But anyway, the UCC and the security agreement is on the debtor side, and the two assets balance each other out. but you just never told them to apply the funds from the one side to the other side and zero the account or do the set-off. And then any time that the beneficiary and the trustee become one and the same, the trust terminates and they have a duty to distribute the funds. And if the promissory note is spelling out who the payee is as the beneficiary and the bank is the payee, they should have gotten paid. But since we didn't express it, it's being construed under UCC as negotiable, and they're taking the instrument because you abandoned it. They've invested it by securitizing it, and really all those assets are really yours, and you could really get that back also through trust law.
Christian, have you been successful in practice with these theories with your clients?
Well, yeah, we've had some successes of stopping mortgage foreclosures right on the sale block, but now we're trying to refine it more and come in with the more sophisticated indenture expressing the trust in the private, because just walking into court with an NOI, notice of interest, saying that I'm the grantor is not sufficient without the SOI, which is a statement of interest, which is the material facts to support that I am the grantor. And there's where we've come in with the SS5 Social Security application, revamped that, did a reapplication saying we've lost the card, and upon the reapplication we take and sign that with a specific restricted signature as grantor, and we're using that to create a title of grantorship, and then we're going to claim that title, and that claiming of that title after we express that we're the grantor and the beneficiary is the evidence that we're going to use as the SOI, the material fact, to support that NOI statement that we are the grantor. Now we've got the evidence and the proof to prove that we have the authority to now issue the instructions as grantor. So that's the first thing to do. What we're doing is we're really proving standing, that we have the authority to come in and say and give the orders. Once that's established, and when you file that, claim those titles, that the SS5 application and the beneficiary card, when we got those, we signed them by grantor, and then when the card came in, we signed that by beneficiary, that we created the title. Then we claim it on a UCC1, and collateral block 4 is ours. Claim the title, claim that grantor status and that beneficiary status on there, and then do a county recording notice of that, and those two public witnesses are what we need to establish a record that's going to prove that we are who we say we are. And that's going to be evidence that you're going to bring in chambers to prove that fact. And then you could put your specifics down as that this case it now becomes the negotiable instrument or the promissory note to settle and close itself. Or you could use it as a promissory note in a mortgage closing or in a mortgage case in a court. That is the specific trust res.
Aren't you also accepting for value the Declaration of Independence somewhere in that process?
Yeah, if I have to get that high up, yeah, I could bring that in later.
Okay. I wasn't sure if that was one of your primary steps.
Yeah, I would have that done, yeah, just in case I needed an extra hammer, a sledgehammer to bring in.
Right.
I'm trying to work on a sub-trust level, which is really the Sesticate birth certificate and the Social Security number trust.
Yeah, yep.
And that on a court level and all in commerce, that's the funds that they're trying to access.
Yeah.
So we're all functioning on a sub-trust level here, but yet that declaration is the master trust. And, that might be too much truth in the public side, but
okay.
Yeah, that would be my ultimate, or even the Bible. I think we talked about that once too before. The Bible would be the ultimate one.
Exactly. Yeah, you did mention that once before. I think we actually posted some information on how to obtain a certified copy of the Declaration of Independence
Right.
on our TalkShoe or our Yahoo group, The Free Americans. It's posted out there. Hey, folks, if you got any questions, go ahead and hit *8 on your phone, and we can run some of those questions by Christian here. It's at the top of the hour. It's 8 o'clock Central, 9 o'clock Eastern Time. We've been going for about an hour now. Christian, if you're ready, we could take a call. I got a one caller that does have a question.
Okay, go ahead. Yeah.
Go ahead. You've been unmuted.
Hey, how you doing?
Good.
Hey, what was that part you were saying about the bank as trustee and the bank as the beneficiary? Where were you reading that part from?
I wasn't reading that from any place. That was that's just a known fact that any time the beneficiary and the trustee are one and the same, the trust terminates. It can't function.
Okay, so that is that just the same as like one of the bank's employees is the trustee, and then the bank is listed as the beneficiary. That's the same thing, isn't it?
Well, I was specifically making reference to, say, if the title company was holding your promissory note in escrow, but yet they're depositing it in the bank, and their bank account is the same bank that is listed as the payee on the promissory note, the bank is the beneficiary, and then they might be classified as the agent of the bank, the title company, and then the bank would essentially be beneficiary and trustee, and that would terminate the trust, and they should automatically pay themselves. They should automatically switch it from the asset side where the promissory note is to the debt side where the UCC and security agreement is, and cancel the two out. So that could work to your benefit. So that's why I said check in your title companies where they deposited your promissory notes. Where are they holding them in trust? Or what if it was with the same bank that's listed as the payee on the note, then the beneficiary and trustee are one and the same.
Oh, yeah, that's what you're saying. Yeah, okay. All right, thanks.
All right, we have another caller with a question, Christian. Go ahead, you've been unmuted.
Can you hear me? Hey,
yeah,
Christian, how you doing? You mentioned something, I didn't catch it, right after you mentioned the note of interest. What was the thing you mentioned right after that? It was something else of interest.
After the note.
Notice of interest and statement of interest.
Oh, okay. NOI is notice of interest, which is, hey, you broke my arm. And then you have to have an SOI following your NOI. And the SOI is a statement of interest.
Okay.
A statement of interest is a material fact, a record.
Okay. Now, let's say you're going back on a foreclosure.
Report of an NOI, or else your NOI times out.
Okay.
In other words,
now,
I broke my arm, and I don't come in with a record, SOI, which would be a doctor's report, x-rays, a bill, and all that stuff, an affidavit that somebody saw you hit me with a baseball bat.
Evidence.
Then within a certain amount of time, the NOI disappears, it evaporates, it times out.
I see. Now, when typically, like, where you're...
We put that in a case, basically, and we didn't come in with the SOI. And within 30 days, the same foreclosure that was taken off the sale block was rescheduled for foreclosure again.
Now, what if you're going after a foreclosed property, let's say happened several years ago, where the party just noticed that there was an affidavit of lost note, which you're attacking under a petition to vacate or void judgment, where you can still go back in with your forms 90, 91, 28, and as well as your notice. Is that correct?
Yeah, but I don't know if I want to do it that way. I would want to, express it being a trust first instead of it's construing it to be a debtor-creditor. Because most of the time we're functioning in court as debtor-creditors.
Okay.
I want to come out of that realm by expressing the trust first, that it was a trust. and that there was a trust duty on the as a trustee, and they didn't do the duty because I didn't issue the order. But now I'm issuing the order. I want the note back. Issue the order for the note back, and now if they don't give me the note back within a time limit, now, okay, give me the proceeds of the note then.
Now, how are you expressing it? Just by notice?
Note, then what I want you to do is we got a problem here because now we got a breach of trust. We got a breach of fiduciary duty because I want you to apply the proceeds of the note times the on the other side of the liability side and balance the account out.
Now, how are you expressing the trust? By notice? By some pleading?
Yeah, that's what we were trying to go over when I first started talking. You know, I'm trying to express the elements of the trust so we make sure that we have a trust. I want to set up the fact that I am the grantor and I can prove it. And I want to do that in private chambers by letter rogatory, not giving the details of the expression of the trust only in detail in chambers and only by notice on the public side of the court.
Okay.
And that's what I was trying to point out by the 4 lines. That was just the notice, and that's just the NOI, but I had to come up with the SOI in chambers. The NOI is now, you know, without waiving any right remedy defense, whereas I, the real man, and then blah, blah, blah. That's the NOI in court. I've given them notice that there's a trust. But when the judge asked me, what's this trust stuff here in the opening lines? Well, I'll be glad to talk to you about that in chambers. Put a protective order on this because it's secret, it's private, because you're going to waive it.
I see. Now, you're a very hard person to reach. I've tried to send you a few emails. I know that, is there any easy way to contact you off the show?
I
was thinking about homing pigeons.
Well, I know everybody has a problem. They would like to get a hold of me and talk to me, but I'm going to tell you this. It is more important for me to look at this as a whole and get this figured out and get the details all ironed out so that, you know, I can help one specific person, but I can't help you all. And that's what the problem is, you know. I don't have enough hours in a day to help you all. And it's better if I devote my time onto this and get it all down, and then we can come out with the workshops that I'm planning, and we can lay it all out on the table, and we can come out with this expressing of the trust versus debtor-creditor UCC filing and all that other stuff.
But do you answer any of your emails on occasion?
Yeah, I do. I check my emails. I don't answer them all.
Okay. All right, I'll send you one. I thank you for your time.
Yeah, you know, here's what you need to do. You need to send me an email so I put you on my list. Because when all this comes down, I got the email list ready to go, and I can announce it all out.
Okay.
You know, I'm pressed for time right now, and I got a lot of stuff I'm working on for research. And
I am same here. Not enough hours in a day.
Yeah, I know there's not.
I do a lot of research. I contact Harold. He's just as busy.
Yeah, well, my email is movingtitles@hushmail.com.
Yeah, I have. Talk to you soon.
Movingtitles@hushmail.com. So you can send me an email there. Don't send me a bunch of spam or anything because, you know,
I don't
block it.
Okay, thanks. I appreciate it.
You know, if you got some specific problems, you know, you can mention them to me, you know.
Okay, very good. Thank you.
All right. Well, that's all we have for callers with questions. I don't know if you want to share any other points, Christian, but if not, then we could probably wind it down for the night and resume next Wednesday.
Well, you know, it's all this stuff is really, you know, this is pretty new. I don't hear anybody really talking about this expressing the trust stuff, especially the way I'm kind of using it. It's, you know, everybody's more in the commerce realm there, which I understand that. But with this trust stuff, it takes you in the next level up, and
right.
you know, all these colorable contracts are really hiding the core, and the core is really the trusts.
It's very
It
powerful.
all looks like contracts, but they're all contracts. They're colorable. That means they're all lies, because you can't have a contract if you don't have any money. You can't complete a contract.
It's all deception.
Yeah. So what is functioning? Well, when you can't complete a contract, then a trust has to come in to form the void, fill in the void. And here's been trust law that's all along been functioning, and we've been trying to fight all this stuff with commerce under commercial venues, which we've had successes at. But to get this trust thing down, it leads to the heart of terminating the Cesta case Social Security straw man trusts and gaining the total access to the funds that are in there, which are some $3.5 billion on the low side plus.
This reminds me of all of the wars that we've fought and how the media has always portrayed a boogeyman, and the American public has focused on that boogeyman, whether it's Japan, Germany, Al-Qaeda, Iraq, when in reality, what's really going on behind the scenes is the bankers are creating these wars. They're funding both sides so that they can generate huge profits in contracts. Yet nobody even suspects to look at the bankers because they're doing everything covertly behind the scenes, just like these trusts. We're all focused on commerce, like you said, in contracts, when in reality it's the trusts that are driving the whole thing.
Right. All that is happening because we've been ignorant, and they haven't been obligated to tell us really that they should have, because it would have been fair and equity, but trouble is fair and equity is not, in this colorable realm, not that anymore. So it's really, we dropped the ball first. It's our first responsibility. Now, I'm not saying that they're not culpable, but really, we should be pointing the fingers at us. If we want to make any changes, we're going to have to do it anyway.
Gene Keating recommended a very powerful book on an audio that I listened called Zero Limits by Joe Vitale. And it goes exactly along those lines, Christian, of taking responsibility for yourself, taking responsibility for your actions. And more importantly, if you have a problem with something outside of you, that problem really is an expression of something on the inside of you, whether it's bad programming or something that's happened in the past that you're dealing with, and it's manifesting in those around you. So I highly recommend, if you have not read the book, to get it. It's called Zero Limits by Joe Vitale.
Yeah, we're responsible for the kind of government that we have. We've created exactly our nightmare, and we are living in it. We dig our own holes. We're living in our own holes, and now if you don't like the hole we're living in, then we need to change it. And that's what I tend to do, is change on this. It's like, won't you join me in, we're in a battle for truth, justice, and the American way, so that the last vestiges of America are not swallowed up by the United States.
Exactly. Well, I'm with you.
We get this trust stuff down, we have the ability to terminate the sub-trust, the straw man trust, and gain total access to all the funds that are in there. Now, whether that's through the DTC or whether that's through the Federal Reserve or another way, it all functions the same as on a mortgage foreclosure or a court case. It's all the same thing.
OID filing.
Get that black card from the Federal Reserve and be totally out of the system, and use that and turn in all these fiction credentials of the driver's license and the birth certificates and the Social Security cards and all the other things, adhesion contracts with it, and then we can get the do not detain and the computer that gives us access to the funds, and they leave us alone.
Have you figured out how to do that yet?
Well, I wouldn't say I've figured out how to do it. I have some darn good ideas, but it all is the same way. And it turns out it's a lot simpler than what everybody else is, what we've been using in the past. So it's this principle, really. Keep it simple, stupid.
Yep.
And here it is, so simple, right in front of us that we didn't know it. All we had to do was express the trust.
Yeah, exactly. So we're really just discovering who we are, and then enforcing that and expressing it through our NOI and SOI.
theory is now the DTC is holding the birth certificates, and that we need to go to them and ask them for a competency to have access to our trust. I don't think so.
No, you make a declaration.
We are in DTC already, and I don't have to be competent and ask them for anything because that would be precatory language.
Exactly.
So I need to understand how it functions and then make the directive or the order or the command to release the funds because I'm the grantor, I'm the beneficiary, and you guys are the trustees. So now distribute the funds. All I had to do is issue the order, but first establish who I am, that I am the grantor position.
Christian, aren't they just holding those funds for us in trust?
Yes, but you're never expressing and commanding them to release them.
It's like Pandora's box. You have to know exactly what to press to get the thing to open.
Yeah, when you didn't express it, they construed it to be under debtor-creditor law, and if you would have expressed it, it would have been under trust law, and you wouldn't have been under debtor-creditor law, under U.S. statutes and codes.
But the good news is you can always go back. It's not too late to undo that and express it correctly.
Right.
Beautiful. Well, thank you for your time tonight, Christian. And we're going to go ahead and close it down for the night. But if you haven't had a chance, go out to the Free Americans, the Yahoo group. The website is groups.yahoo.com/group/the Free Americans. And if you're not a member, become a member and you can join. There's a lot of good information out there. Christian has done a great job tonight of sharing this information, and I'd like to encourage you to come back next week for another session of our weekly conference called The Free Americans.
We're going to talk about this property, the res, next time.
We're going to talk about the res. Excellent. Well, I'll be sure to put that in our weekly reminder for our subject for next week to discuss the res. Thank you, Christian.
Okay.
Have a great evening. All right, we'll talk to you next week. Bye, Al.